Good morning, everybody. My name's Ben Palmer. I'm from Oakwood Solicitors. I head up the Employment Law Department at Oakwood Solicitors, which is based in Leeds. As those of you who've had your cup of coffee this morning will have noticed, I'm doing this live broadcast under the name of Lindsay Palmer. The reason for that is I don't have a Facebook account, but my wife does, so I'm using her login details. So this morning I'm going to be discussing about Covid-19, how it's impacted the workforce and the provisions that the government has put in place to assist both employer and employees in relation to this lockdown and difficult period. The issues I'll be discussing today are those that I believe are most relevant during this period of lockdown and Covid-19, and that is the provisions in relation to sick pay, childcare and furlough. I imagine furlough is going to be an issue that's on a lot of people's minds at the moment, both from an employer and employee perspective. I will go through these topics in some detail. If you do have any questions, then please do post those and I will address the questions at the end. So, looking at sick pay, the government has made a number of changes to the sick pay provisions, particularly in relation to short-term sickness absence. So, previously, an employee would have to wait until the fourth day of sickness, so I'd had a phone call then, fourth day of sickness, before they were entitled to claim SSP. The government changed that, so it's now from day one. And the reason for that is the government was concerned that employees may go into work because of the issue regarding lost pay, and then thus spread the coronavirus. So SSP is now available from day one. Employees are still required to follow the employer's absence reporting process, but they can self-certify for the first 7 days of sickness. After that, employees will be required to obtain a GP fit note. Now, because of the fact that the NHS and GP services are overwhelmed at the moment, the government has set up an isolation note, and that can be obtained from the NHS 111 website, and an employee can print out that isolation note, and that counts as a sick note for SSP purposes. A new concept introduced by the government in terms of SSP entitlement is that of isolating. So an employee may isolate if they believe that they're at risk of spreading the infection. So the guidance gives the example of somebody within their household is suspected of having Covid-19, and they then must self-isolate for 14 days. Again, the employee can go onto the NHS 111 website and print off the self-isolation note and provide that to their employer, and then they'll be entitled to SSP. Now, SSP for the first 14 days can be claimed back from the government by the employer. Another new concept is that of shielding. Shielding is a government provision specifically aimed at employees who are considered clinically extremely vulnerable. So it might be that they have symptoms such as conditions such as cancer or a suppressed immune system, perhaps have had a transplant or are undergoing chemotherapy. The government has advised that those people who fit this definition of clinically extremely vulnerable must self-isolate until at least the end of June, and that may well be extended. There is online guidance under the government website about who fits into that definition of clinically extremely vulnerable. The government has confirmed very recently that those people who are shielding are entitled to SSP. It's not clear at the moment whether or not they can opt or the employer can opt instead to furlough those employees. What is clear though is employees who are shielding and furloughed aren't entitled to both SSP and furlough pay. Now, I've mentioned the term furlough quite a few times. I will be getting onto what furlough is a little bit later in this talk. So the next thing I wanted to discuss with you is about childcare provision. So an existing entitlement for childcare is parental leave. So parental leave is when an employee can take up to 4 weeks unpaid leave per year to look after their child. So this is particularly relevant during this time because of course the schools and child minding facilities have been closed down for the foreseeable future. Of course, no data is yet announced by the government as to when schools may open. Obviously, we've got the exception of schooling and childcare for key workers, but if you're not a key worker, then you may well be like myself and my wife, looking after your child at home. If your nature of your job means that you have to go to work, so for example it might be a single parent who's a cleaner, then they may choose to use parental leave and to look after their child during this time. As mentioned, parental leave is unpaid, but it does have some benefits over just taking simply unpaid leave. So an employer cannot refuse a request for parental leave. They can delay the request if there are exceptional business circumstances to do so, but they cannot refuse it. Also, parental leave, if taken, affords the employee some protection against their employer then subjecting them to detriment. The government has announced that for those people who have taken parental leave after the 28th of February, their employer can furlough them instead of being on parental leave. Now, I'd imagine that most employers would agree to furlough staff in those circumstances because it's more beneficial to the employee and is of no real detriment to the employer. But if for whatever reason the employer doesn't agree to furlough, then the parental leave may well be a good option for those who have to care for their child during this time period. It is for 4 weeks, so after that period, an employee could potentially use their annual leave entitlement. So the main provision that the government has put in place during this time is that of furlough leave. So it didn't exist until March this year. The government has provided lots of guidance between March and now in terms of how the furlough leaves provision is going to work, and they have really been making it up as they've been going along. So things have been changing rapidly. So as I stated at the beginning of this talk, the information I'm providing today is correct as of today, but that doesn't necessarily mean it'll be correct tomorrow. So furlough leave and the guidance in relation to it, it is dealt with under the government's coronavirus job retention scheme. And the idea of furlough is that employees remain employed by their employer, but cannot do any work for the employer that is likely to generate any revenue for that employer. So the employee will be able to undertake things like training, but won't be able to do any sort of normal day-to-day work. The period of furlough is a minimum of 3 weeks. So it has to be a 3-week stint. During that 3-week period, the employee can take annual leave. So for example, we've recently had a bank holiday. The bank holiday will not have broken the furlough 3-week period for those staff. The government has also confirmed that furlough can be on a rota basis. So for example, an employer may decide to furlough somebody for 3 weeks, have them back into the business, and then furlough another employee for 3 weeks. And that is an advantage to both employer and employee, because from an employer's perspective, it makes sure that there are no skills lost by having furloughed an employee for a very long period of time. And from the employee's point of view, it means they are only having a reduced salary for a 3-week period, and also the issues of being locked down at home may well have welfare and mental health considerations. So the furlough scheme is available to any employee that was employed through the payroll system from the 19th of March 2020. In order for the employer to use the scheme, then there are certain requirements that the employer-employee must satisfy, and the main one being that the arrangements for furlough must be confirmed in writing. So the employer must state that the employee is going to be furloughed for a minimum of 21 days, that the employee agrees to be furloughed, that they agree not to carry out any work whilst furloughed, and that the reason that they are being furloughed is a reason related to Covid-19. So what entitlements are employees entitled to under the furlough scheme? So an employee will be entitled to 80% of their pay, or £2,500, whichever is the lower. So if somebody's on £100,000, then they'll be entitled to the cap of £100,000 per year. Then they'll be entitled to the cap of £2,500, and the employer can then claim that money back from the government. And the employer can also claim back employers' national insurance and auto-enrolment contributions on that 80% or cap of £2,500. A common question that I get asked is an employer required to top up the remaining 20% of pay? And the answer to that is no, they're not. Some employers we have found, particularly with larger organisations, are making up the difference in lost pay for employees, but certainly our SME clients, so our small to medium-sized employers, are not able to make up that difference for the staff that they furlough during this time. So the period for which an employee can claim back the salary under furlough is for the period the 1st of March to the end of June. Now, it may well be that the furlough scheme is extended by the government after June, but we just don't know at this stage. The way in which an employee retains the rebate under the furlough scheme is through an online portal, and that online portal opened today at 5:30 this morning. The early reports are that it's a fairly easy system to use, and the HMRC has stated that for those people who put in their, so those employees who put in their applications for the rebate today, should receive the rebate money on the 30th of April. After that, the HMRC believes that once an application has been made under the furlough scheme by an employer, that the rebate will take 4 to 6 working days. Very, very importantly, from a cash flow point of view, for many small employers, the application can be made in advance of payroll. So it can be made up to 14 days in advance. So if an employer puts in an application, say on the 1st of June, and they are not due to pay staff to the 14th of June, then it may well be that in the first week of June, they actually receive that money in their bank account before then having to pay salaries. The government is talking at the moment about making it a criminal offence for employers or employees to abuse the furlough scheme. But at this point in time, the provisions in relation to that are fairly unclear, and I don't think the government has yet decided what's its position going to be in relation to abuse of the furlough scheme. We've also been told that the information that's required under the portal in terms of what employees have to provide, it is fairly limited, and there's going to be not much investigation by HMRC in terms of the claims that are put forward as of now. But that of course doesn't mean to say that the HMRC won't do a much more thorough investigation once the situation has calmed down and retrospectively. So I have now dealt with the provisions in relation to sick pay, how they relate to sickness, self-isolation and shielding. I've also discussed about provisions in relation to childcare and furlough, and then also about furlough leave itself. If you do have any questions, then I'd be more than happy to answer those for you now if you'd like to post a comment. The advice that I'd be providing would be more general information rather than advice on a specific case, because of course every situation is dependent on its facts, and it isn't possible for me to give you full legal advice during this broadcast. But of course, if you do want to get in touch with me at Oakwood Solicitor, I'd be more than happy to assist in dealing with any specific issues that you have in detail if they need to be done so. But at the moment, if you do provide any questions, I'd be more than happy to answer those. I'm just going to have a quick look at my phone now. See if we've got any questions. Okay, and we don't appear to have any questions at the moment, so I'll just deal with two questions that I do get asked frequently. One is, are employees entitled to national minimum wage whilst furloughed? So if an employee is currently on national minimum wage and then are furloughed, then they'll be effectively receiving 80% of their salary, which will be less than minimum wage. What the government has said is that employees who are furloughed are not entitled to national minimum wage unless they're doing an activity for the employer. Now, the activities, as mentioned before, are fairly limited and are effectively tasks like training. So if an employee is training whilst being furloughed, then they will be entitled to national minimum wage. We have another question here, which is in relation to apprentices and whether or not they are entitled to be furloughed. The answer to that is yes, they are, if they are paid at least the applicable apprenticeship rate of pay. But yes, otherwise they'll be treated in the same way as any other employee. A similar question is, are casual workers entitled to be furloughed? So casual workers, or previously referred to as 0-hour workers, are entitled to be furloughed. However, because somebody who's a casual worker isn't entitled to be given work by their employer, some employers may think, well, actually, why furlough somebody when I can just not offer them any work during this time? As furlough, it is a cost-neutral position for an employer. It would be hoped that an employer would furlough staff who are on 0 hours, and the calculation that they use is the previous salary that's been given to those employees as an average when working out the 80% pay. There is online guidance on the exact calculation of how to do that on the government website. So I've been asked a question about self-employment. So if you're self-employed, that falls out the remit of of employment law, there are provisions similar to the furlough scheme that have been announced by the government, but that falls outside my area of expertise, because my expertise is in relation to the relationship between employers and employees rather than self-employed. I've got another question here, which is there any indication of the coming tax implications of accepting employees on the scheme? All indications show, I'm just clicking on more here. Unfortunately, I can't see the rest of that message. Sorry, I've got it now. That this money will be recouped at some point. So I think that's a question in relation to when employers will receive back the money under the furlough scheme, which I've already dealt with. So that would be, if an application is put in today, it should be recouped back by the 30th of April. And then after that, it will be 4 to 6 working days following any future submissions. If the question is relating to individuals' tax, then employee tax will be taxed at source by the employer under the PAYE, as it normally would be. So I think that if anybody's got any further questions, then please do ask now. Otherwise, please do post a comment later today, and I will have a look at the post, and we'll answer those questions later in the day. I hope you have all found this whistle-stop tour of the government's provisions during this lockdown period useful. If I can assist with anything, then please do get in contact with me. Thank you. Bye-bye.